everyone. I think we'll get started. Thank you for coming to the Land Court Breakout session. I guess I should make sure everyone understands this is the Land Court Breakout session. The Probate and Family Court Breakout session is downstairs. I am Bob Foster. I'm the judge on the Land Court. With me is Don Pinto. Don Pinto's a partner in Rackman, Sawyer, and Brewster, and has many years of experience litigating in the land court. In fact, more experience than I did litigating in the land court. So between the two of us, we'll discuss practice in the land court, some of the specific rules we have and procedures, the Land Court LAR order and how that will work, and then some of the kinds of cases that typically come in the land court and how LAR might be useful in those cases. I want to remind everyone, if you haven't, be sure to sign the sign-up sheet on your way out. Let me ask, before we begin, how many of you have ever appeared in the land court before? How many of you have appeared in the land court more than once? Okay, so that gives us a good idea of the experience level here. So without, which is fine, it's fine. I welcome new practitioners in the land court. Without further ado, I am going to turn this over to Don.
Thank you, Judge Foster. I'm very happy to see very few hands going up because I'm going to talk about very basic things about practice in the land court practice 101. So if you had all been experienced land court practitioners, I would be boring the heck out of you for the next 30 minutes or so. I'm going to talk about a little bit about the history of the land court, and I will keep that brief, I assure you, then talk about land court jurisdiction, and then some of the practice and procedure in the land court that may be a little different than some of you have experienced in other courts, some of the distinctions between land court and the superior court, and then very briefly talk about the mechanics of filing a case in the land court. The land court was founded in 1898 as the Court of Land Registration. The purpose of the land court was to administer the Torrens system, which is also known as the land registration system. The purpose of the land registration system is to avoid uncertainties in title that crop up when you have private practitioners examining titles and private practitioners offering their opinions on the quality of a title. So the thought was in the 1800s to turn that over to professionals, and the land court was created to do the research of titles. Essentially a landowner presents a petition for registration, and then the land court does the title examination, and if it finds that the title is good, issues a certificate of title that's good against the world. And one of the principal advantages, besides the certainty of having a court-certified title, is that adverse possession and prescription don't run against registered land. Once the land is registered, all proceedings involving that land thereafter have to be run through the court. All liens, encumbrances, any deeds of the property have to be registered with the court, and they're noted on the certificate of title, so there's a clear record of ownership and a clear record of encumbrances. And if any of you are interested in the history of the land court, there is a document on the court's website that I highly recommend, which is called A Brief History of the Land Court by Glenn Busher of the land court, and that's on the website, and it's kind of an interesting history if you're a land court buff or you'd like to become one. In any event, in the century after 1898, the jurisdiction of the court expanded greatly beyond the initial jurisdiction over registration cases, and it's now set out in Chapter 185, Section 1, which is in your materials, and it's a fairly long list of cases over which the court has jurisdiction, and I'll just hit a few of the highlights. In addition to registration cases, the court has exclusive jurisdiction over the foreclosure and redemption of tax titles under Chapter 60, writs of entry to recover possession of property under Chapter 237, several different forms of jurisdiction under Chapter 240, including over complaints to determine the validity of encumbrances on property, complaints to discharge obsolete mortgages, complaints to determine the validity and extent of municipal zoning bylaws and ordinances, which is used quite a bit. And then it's got exclusive jurisdiction in some quirky areas that you probably will never run into, like determining the boundary of title flats and determining city and town and county boundaries in the event of a dispute over the town line. In addition to this exclusive jurisdiction, the land court has concurrent jurisdiction with the Superior Court, and there's a catch-all paragraph which covers a huge amount of territory, which is the court has jurisdiction concurrent with the Superior Court over all cases cognizable under, excuse me, under general principles of equity jurisprudence where any right, title, or interest in land is involved, including specific performance of contracts where right, title, or interest in land is involved. So if there's no specific grant of jurisdiction, virtually any case can be brought under that catch-all paragraph in the land court, as long as it involves right, title, or interest in land in almost any way. In addition to that catch-all, the court has jurisdiction over actions of trespass to real estate if they involve title. That's something that confuses people often. They think the land court has jurisdiction over trespass cases generally, but if it doesn't involve a question over ownership or rights in property, the land court will not hear it. The land court also has concurrent jurisdiction with the Superior Court over zoning appeals under Chapter 40A-17, appeals under the subdivision control law, and also actions in the nature of certiorari under Chapter 249, Section 4. Those are administrative appeals. They can involve zoning, subdivision, and other land use regulations. There's one major exception that you should take note of, which is that the court does not have jurisdiction over appeals under the Wetlands Protection Act or under municipal wetlands bylaws, which have to be brought in Superior Court. Those are also administrative appeals under Chapter 249-4, but because of some quirks in the language of some amendments to the Superior Court and Land Court jurisdictional statutes, that jurisdiction lies only in the Superior Court. And lastly, in addition to the court's concurrent jurisdiction with Superior Court, the Land Court has concurrent jurisdiction with the Probate Court over petitions to partition land. In terms of procedure in the land court, the rules of civil procedure fully apply in the land court in all their glory. So all the typical discovery procedures are available and apply, and you just need to read the rules of civil procedure in terms of those basic procedures. The land court does have its own set of land court rules, which vary from the Superior Court in some respects, so you need to also pay attention to the land court rules and standing orders, and there's a copy of the land court rules in your materials. One of the main differences in practice in the land court is the case management conference. When you file a case in Superior Court, as some of you may know, the court doesn't get involved until virtually it's time for a pretrial conference, or if somebody files a motion and brings the case to the court's attention. That's not the case in the land court, and this is one of the great benefits, in my view, of the land court, is that within 2 to 4 weeks of filing a new case in the land court, you'll get a notice of a case management conference. And this is an early conference where counsel go to the court. Most of the judges handle them informally. You sit at a table with the judge, everybody introduces themselves, and counsel before the conference have to cooperate and produce a joint memorandum called a case management statement. It's fairly basic, but it does require the counsel to each set out their position, to mention any difficult or unusual legal issues that the case presents, propose a discovery schedule, propose deadlines for filing dispositive motions, and also discuss alternative dispute resolution and whether counsel think that the case is amenable to mediation or some other alternative dispute resolution. And the court's order also requires the plaintiff to make a settlement proposal in writing in advance of the case management conference. That is not to be disclosed to the court, but it needs to be done. The parties need to be prepared to talk about that at the case management conference.
I just want to emphasize how important we consider the case management conference. It's a key event to the court, to the judges, and we take it very seriously. So that's a real event. We'll look closely at things like scheduling of motions and discovery. We'll find out what the case is about. We'll probe about settlement and ADR. We have the authority to order the parties to an ADR screening, which is at no cost to the parties. And that screening is provided by one of several ADR providers on our list. And when you go to that, they'll talk to you about the case, and at that point you can decide if you want to do mediation or not. So the case management conference is important. The case management conference statement is important, and it's very important that the case management conference statement be filed before the case management conference so that I have a chance to look at it the day before, the week before, whenever it's due.
Most of the case management orders I've gotten require the statement to be filed 5 business days before the conference, and we do try hard to do that, to give the judges an opportunity to read and be familiar with the case before we come in. I have to say, when the court proposed adopting this new procedure to have a case management conference, which it's been probably 5 years or 7 years, something like that, it was very different from the practice I was used to, and I was skeptical that it would be a worthwhile exercise, because it does require filing yet another memorandum with the court in advance of the conference. But I have to say, in the fullness of time, I've really come to appreciate the case management conference, because it forces me and forces opposing counsel to really reckon with the case and be able to describe in writing what the claims are and frame them in a way that's understandable to the judge. Might require you to check yourself and see if your claims are as good as you thought they are. It gives you an opportunity to hear in writing from the other side how they view the case. And it just gets counsel together in advance at an early stage of the case, and sometimes that can produce some good results for the clients, especially if there's an agreement that the case could be settled and that the parties will try mediation rather than marching ahead down the litigation path, which obviously gets very expensive quickly for everyone. Another difference in land court practice as compared with Superior Court is that in the land court, except for dispositive motions, motions can be marked for hearing by the moving party. So unlike Superior Court, where you serve your motion under Rule 9A, you wait for a response, and then the moving party files a package with the Superior Court, which proceeds to sit in the Superior Court for sometimes weeks or months before you hear anything about your motion. In the land court, again, accepting summary judgment motions and motions to dismiss. If you have a non-dispositive motion, you look in Lawyers Weekly or on the court's website to see when the judge assigned to your case has a motion session to hear motions, and you can mark it up on 7 days' notice to the other side. The court very strongly encourages you to contact the other side and try to come up with a mutually agreeable date, at least 7 days from the date of the motion filing, so that you don't have a back and forth series of postponements to a date that's convenient for everyone. Dispositive motions are covered by a land court Rule 4. Again, somewhat different from Superior Court, but some similarities as well. Land Court Rule 4 has been amended several times. It now requires, in the case of a summary judgment motion, a detailed statement of the facts that the moving party thinks are undisputed, and then a detailed response to each of those numbered paragraphs by the non-moving party saying undisputed or disputed, and every assertion of fact and every response has to have a citation to some document of record that substantiates the response, and then the parties each have to file an appendix of cited documents along with the motion. This ensures that motions for summary judgment are well-founded, or at least there's a argument that they're well-founded before they get to the court, and then the court is able to look at one set of papers and see very clearly what the undisputed facts are and what the response to each fact is. Another benefit of the land court, unlike Superior Court, the moving party can file a reply brief as of right. In the Superior Court, you need to move for leave to do so, but in the land court, you do get a reply brief as of right. Perhaps the best quality of the land court, and in terms of differences with Superior Court, the one that I find most beneficial is that in the land court, you do get one judge assigned to your case. When you file the case, it's assigned to one of the 7 judges, and that judge keeps your case, barring some unusual circumstance, keeps the case throughout its life. So in Superior Court, you might find 2 or 3 or 4 different judges cycling through the session that your case is filed in. Not so in the land court, so you avoid having to re-educate the judge. Each time you go to court, the judges know your case, and based on the case management conference, they get to know it fairly well, and the next time you see that judge, you can kind of pick up right where you left off and get right to the heart of the matter. It's also easier for scheduling because you're only dealing with one judge's calendar in terms of scheduling hearings or trials. You have one judge for the life of your case. In terms of mechanics, it's at some point the case proceeds just like any other case. But in the early stages, we've talked about the case management conference. The land court has its own civil cover sheet, different from the Superior Courts, and there's a civil cover sheet in your materials as well. The main feature of the civil cover sheet is that it requires you to check off a box identifying the principal claim and then any additional claims you're bringing. And this basically tracks Chapter 185, Section 1. It helps the filer of the case as well as the court ensure that the court has jurisdiction over the case that you're bringing. And now, as of just recently, the civil cover sheet has been amended to include a certification concerning LAR. And so the counsel, as they file the case, certifies that they're aware of and will comply with the requirement that a copy of the LAR information sheet, which is also in your materials, will be served on all of the defendants at the same time that the summons and complaint is served. Filing fee is $255, which is a bargain compared to the Superior Court's $275. And again, early on in the case, within a few weeks of filing, you'll get your notice of judge and track assignment, which will tell you which judge has been assigned to your case, also which track your case is placed on in terms of the time standards. And land court, like Superior Court, has a similar set of time standards, and depending on the type of case, it'll be assigned to one of several tracks which dictate presumptive deadlines for various events. But one thing that happens at the case management conference is the parties come to the conference with an idea, a proposal for a schedule for the case, and if that proposal is to move the case along faster or even much faster than the tracking order would require, that's discussed at the conference, and you may very well leave the conference with an order from the court that the deadlines that you've proposed are now the operative deadlines in the case. You also, in that early package from the court, get your scheduling order for the case management conference telling you when to show up and what needs to be in the case management memorandum. Once you go to the case management conference and you agree usually on your schedule, your number of discovery events, the discovery deadline, deadlines for filing dispositive motions, the case then proceeds much like any other case. When you are ready to file your dispositive motion, you can just file it directly with the court in accordance with Land Court Rule 4. If it's a trial case, you can move for a pretrial conference when you're ready. The court will have a conference, much like other courts have pretrial conferences, and will schedule a trial before your assigned judge. Trials in the land court can be scheduled. Most of them, virtually all of them, are jury waived, because the land court's jurisdiction tends to be in jury-free cases. So the court may schedule a day or two of trial, and if a third day is needed, that day might be several weeks or even a month or two. after the fact, but trials do get done in that manner, and then you get your decision.
I want to emphasize, the good news is the trial dates are firm trial dates. They don't get moved. You will go on that day, unlike what happens in Superior Court. The bad news is the trial dates are firm trial dates. We don't give continuances absent an emergency. So keep that in mind.
No, that's a good point. I don't know how many of you have had a lot of Superior Court experience, but the way the Superior Court runs their trial calendar is they will put anywhere from 4 to 6 or 7 cases on for trial on the same day. Generally, they look at them in the order that they were filed. In other words, older cases are near the top of the list. The newer cases are near the bottom of the list. And that's because cases settle at the last minute. Witnesses are unavailable at the last minute. So trial dates in the Superior Court tend to be flimsy at best, and certainly if it's the first trial date you've been assigned, your chances of actually going forward on that day are probably, depending on the court, pretty slim. In the land court, they schedule one trial at a time for one day, and that's the reason why the court considers the dates to be very firm, because if you look for a continuance at the last minute, the court is left with a hole in the schedule, and the judge is left without a trial to have that day. So they take them very seriously, which is ultimately beneficial to counsel, because you know that going in, and unlike Superior Court, when you might prepare to a 10 or 20 or 30% level because you know that there's a very good chance at the very last minute your trial is going to be put off. In the land court, you know you're going forward and you can prepare accordingly, and if the dynamic of being on the eve of trial, as it often does, pushes parties together and promotes a settlement if one can be had, that happens the first time you get a trial date in the land court rather than the 4th or 5th or 6th time. So that's another benefit of being in land court, and a nice thing about the way the land court runs its schedule. That's all I have for land court practice and procedure. I don't know if you want to take questions or you want to go right into your piece.
No, why don't I go into my part, and then we'll take questions. One thing I want to add about the trial practice is it is always a bench trial, and then generally what happens is after the testimonial portion of the trial is completed, each lawyer will prepare post-trial briefs and propose findings of fact and submit those. Usually we ask the lawyers to wait until the transcript of the trial has been prepared, and so they have that, and then base their briefs on the actual transcript. And then once that happens, depending on the judge, some judges have the lawyers back in for a closing argument. At that time, sometimes they do the closings at the close of testimony, and then the judges take it under advisement and write a decision. So what I want to talk about now is, first of all, the actual LAR order in the land court that was effective last week, and which is in your materials, along with some of along with the LAR information sheet and the appearance and the withdrawal, and how these have a few particular requirements that might be somewhat different than the general requirements you just heard about downstairs. The first requirement is that we have prepared a limited assistance representation information sheet, an LAR information sheet. It's 4 pages. It's on our website. And we require that information sheet be served with the summons and complaint. And so if you're coming in as a plaintiff, that's something you should be aware of. And in fact, as Don discussed on the civil cover sheet, among the certifications you'll be signing when you sign the civil cover sheet, you have to certify you've discussed LAR or discussed ADR, with your client, but you also have to certify that you're aware that you're supposed to serve the LAR information sheet. That's our attempt to make sure to spread the news that LAR is available in the land court. Now, if you are going to do an LAR appearance, you have to file the LAR appearance form and the notice of limited appearance, and that's in the materials. And that's like the others you've seen. It does have specified events. We tried to capture what we thought would be the most common events that people might appear for, and you can check the box for that. That also includes a blank space for the date of the event, if you know it. But there is an other box that you can check and then fill in. These forms are on the website as fillable PDFs. So you can go on the website, open it, fill it in, and then save it and print it out. The other thing you need to know is that not only you, but your client has to sign the appearance form. And our sessions clerks are instructed to check to make sure that when a notice of limited appearance comes in, that it's an event has been checked and that both you and your client have signed it. We won't accept it if those things haven't been completed. And we don't keep a list of LAR qualified attorneys. By signing the appearance, you are certifying that you have been trained and qualified for LAR. And by doing this program, you have been trained and qualified for LAR. And once you're in and you appear for your event, it's probably a good idea to let the judge know that you are here as an LAR attorney. But we have made sure that on our dockets that your appearance will be specifically noted as an LAR appearance and that there'll be an entry for what event that you're appearing for. So it won't necessarily be a complete surprise to the judge, but it's probably good practice to let the judge know that you are here as an LAR attorney. And then finally, and the appearance is event-driven. We don't really have a box for issues because we found that we couldn't figure out how to carve things up into issues, so it'll be really strictly for events. Finally, make sure to withdraw afterwards, because as far as we're concerned, until you withdraw, you have appeared. And if you're in until you're out. So if your event is completed but you don't withdraw, you will continue to